Hey, puppy pie. Oh, sorry, I'm live. Outline of fundamental California wage and hour laws. This was written December 1 of 2022. This was written by a local attorney named Aaron Kaufmann of Leonard Carter LLP and in Oakland. And this nice attorney has provided this information for the Coalition of Concerned Legal Professionals. So I read from it now. I do not share it publicly. This is a private video, but should I get permission to make this public? I'm just saying now that this is potentially legal advice, but it really wasn't written for any specific facts or cases in mind, so it really should not be relied on. And also laws are subject to change over time, so if anyone has any specific laws or cases that that they do not rely on the laws I'm about to read, but consult an attorney. Overtime basics, subsection 1. A, accrual of overtime. 1, after 40 hours per week, the Labor Code 510 Industrial Welfare Commission wage orders. Section 3, and after 8 hours a day, according to the same labor code I just read. So that's your accrual of overtime. Secondarily, in subpart B, there's alternative work weeks. Wage order number 4, section 3B, regarding schedules that allow work days exceeding 8 hours per day. And then there's a subsection A again, CBA covered workers. Overtime provisions don't apply if CBA provides for premium wage rates for overtime worked and regularly hourly rate of pay is not less than 30% more than state minimum wage. See Labor Code Section 514. Overtime compensation is the next section. The overtime rate is 1.5 times regular rate of pay, 2 times regular rate of pay for hours over 12 hours a day, or over 8 on the 7th consecutive work days, or consecutive day worked. See Labor Code 510 again, of the Industrial Welfare Commission wage orders. And subpart B under part 2, overtime compensation, coming after the overtime basics I had just read, is the regular rate of pay includes all forms of compensation, not just the straight line rate. It includes adjustments to the straight line rate, such as shift differentials and per hour value of any non-hourly compensation. And this comes from a case called Alvarado versus Dart Container Corp of California, and that was a 2018 case. Another definition of regular rate comes below subpart B. Regular rate refers to regular time, meaning when non-hourly compensation is factored into the regular rate of pay, only non-overtime hours should be considered, and that's from the case Alvarado. And secondarily from that case is that flat rate bonuses must be factored into regular rates, and as does cash in lieu of health benefits. And that is citing the Flores versus City of San Gabriel of 2016. Now, for production bonuses, commissions, and piece rates, workers only get a 0.5 and a 1.0 multiplier for overtime hours instead of the 1.5 and 2.0 multipliers used for salaried and commission workers. Regular rate of pay calculations. There is a footnote here at the bottom of this page. Looking to see what it relates to because it's kind of dark in here. I see. After we introduce the Section 510 of the Industrial Welfare Commission wage orders, Section 3, there was a footnote. There are 17 different wage orders organized by industries. Most of the substantive provisions are the same throughout the wage orders. Wage order number 4 applies to workers in professional officers and many other office settings. Yeah, that's for Sure. I struggle understanding how they apply, to be honest. So I do appreciate this material. Then there is going to be a section 1, 2, and 3. We're still within part 2, so part 2, overtime compensation, but we're within D, which is regular rate of pay calculations. And there are 3. Salaried workers divide week's total compensation by 40 hours. I'm going to skip a example. Number 2, commission and piece rate workers divide week's total compensation by total number of hours worked. So divide week's total compensation by total number of hours worked. Whereas with salaried workers, it was divide the week's total compensation by 40 hours. And third, overtime on flat sum bonuses and similar non-production based pay, for example, cash in lieu, compensation amount regular, non-overtime hours worked times 1.5. So that's a bit of a calculation. So overtime on flat sum bonuses and similar non-production based pay, to calculate that, the calculation is compensation amount divided by regular non-overtime hours worked. Multiply that by 1.5. The DSLE enforcement policies and interpretation manuals, DLSE manual section 49.2 for other examples of overtime calculations gives you subpart E, comp time. Employee may receive compensation time off in lieu over overtime, but comp time accrues the same amount as overtime. For example, 1.5 times regular hourly rate from Labor Code Section 204.3. Requirements for permissible comp time per written agreement between employee or bargaining rep and employer. B, employee hasn't accrued more than 250 hours of comp time. Third, or C, employee has requested comp time in lieu of overtime compensation. And 4, employee is regularly scheduled to work no less than 40 hours a week. Now, probably number 3, but it's number 1, but it would be 3 in order. Under comp time, it says the employee entitled to use comp time within a reasonable time of request. So we're on page 4 because the title page is rather long, but let's just finish here. What is compensable time? And overtime calculations, meal periods, rest periods, pay periods, timing of payment, exemptions to wage and hour requirements. There are some other exceptions, computer professional exemption, other exemptions. Wrongful deductions and indemnification for business expenses, paid time off, independent contractor misclassification, and so there's ultimately 10 more pages to read. So finishing up with comp time, we are at number 5. It probably ought to be under subsection E, comp time. Not permitted in industries governed by wage orders. 1, manufacturing. 5, public housekeeping. 8, handling products after harvest. 10, amusement and recreation. 13, preparing agricultural products for market. And 14, agriculture. And number 6, lastly, makeup time. Wage order number 4, section 3L, allows workers missing work to make up that time without having to make up time count as overtime hours, so long as makeup time is performed during same week missed work. Worker does not work more than 11 hours in one day or 40 hours in a week, and makeup time must be per employee's written request. What is compensable time? This is subpart 3. Employee must be paid for all hours worked from Troester or Starbucks in 2018. Hours worked includes the time during which an employee is subject to the control of the employer and includes all of the time the employee has suffered or permitted to work, whether or not required to do so. Wage order number 4, section 2H. Compensable time may include 1. Work from home or away from job site. 2. Meal periods in which employee is not relieved of all duties for at least 30 minutes. See Bono Enterprises, Inc. versus Bradshaw in 1995. On call and standby time, including whether employer maintains degree of control such that employee can't effectively use time for his or her own purposes. Mendiola versus CPS Security Systems. That is a 2015 California case. These are all California cases unless I give otherwise, but there's also a citation 29 of the Code of Federal Regulations, section 785-17. Sleep time generally cannot be deducted from compensated time. See Mendiola. Show up reporting time. Employee relieved of duties after working less than half scheduled shift, then must be paid for a half shift, minimum of 2, no more than 4 hours. Worker order number 4, section 5. Calling in or being reachable in order to promptly report to work may trigger reporting time pay. Ward vs. Tilly's, Inc., 2019. Wood vs. Marathon Reef Logistics Services, 2020. Calling in or being, okay, I just read that. Travel time, normal commute time, home to work, not compensable, but travel time may be compensable. I already read page 3. And there's page 4 again. So I remember copying this and making a couple mistakes. So we're on page 5. If an employer requires an employee to use transport provided by the employer and or does not allow employees to commute on their own, see Marillion versus Royal Packing Company, a 2000 case. And if the employee must engage in job-related travel during the workday, see 29 Code of Federal Regulations, section 785 again, point 33 through point 38. Whereas the last citation was section 17 or point 17. If work-related travel out of the area. Now, third under this section is titled Security Checks. Time spent in security checks is compensable. Whether on-site employer-controlled activities are compensable turns on whether the activity is required, the location of the activity, the degree of the employer's control, whether the activity primarily benefits the employer or the employer, and whether the activity is enforced through disciplinary measures. Training time. Now that gives you the case Freaklin versus Apple Inc., 2020, as a citation. And then training time, whether compensable, turns on several factors. 29 Code of Federal Regulations, section 785.27 through 31. Is attendance outside regular working hours? Is attendance voluntary? Is training manual not directly related to the employee's duties? And does the employee perform any productive work during training? Must be paid at least minimum wage for every hour of work. See Armenta versus Omos, Inc. in 2006, and Antiveros versus Zamora in 2009. Both of those, all of them that I'm given here are from California. Still, so confirming that. And failure. Okay, so the notes here as it states must be paid at least minimum wage for every hour worked. The notes 1 and 2 read, failure to pay minimum wage for each hour worked could lead to liquidated damages of 2 times the minimum wage from the Labor Code section 1194.2a. And 2, a piece rate formula that does not compensate directly for all time work does not comply with California labor codes. Even if averaged out, it would pay at least minimum wage for all hours worked. Cardenas versus McLean Food Services, Inc., 2011. Then there are meal times on page 6. Subsection A, Labor Code, Section 512 and Wage Order Number 4, Section 11 provide unpaid off-duty meal periods. 1 must be relieved of all duties for half hour if work more than 5 hours, and subpart A, or lowercase letter A, can waive in writing if working 6 hours or less. Now, number 2 under subsection A reads second meal period if work is more than 10 hours. Lowercase a can be waived if working 12 hours or less. And third is a worker is owed 1 hour of pay for every day not afforded proper meal periods. Wage Order Number 4, Section 11, Labor Code, Section 226.7c. To provide proper meal period, employee must be relieved of all duties. Brinker, Restaurant Corp. versus Superior Court, 53 California 4th, 2012. 1 means no work and free to leave the premises. 2, to relieve employer must relinquish control over the activities, permit workers reasonable opportunity to take an uninterrupted 30-minute break, and cannot impede or discourage them from doing so. Subpart D, employer must record off-duty meal periods, Labor Code 226A. On-duty meal periods allowed if employee agrees in writing, agreement is revocable, and nature of work prevents employer from providing off-duty meal period. And last, subpart F, CBA may carve out from meal period requirement certain employees in construction, commercial driving, wholesale banking, motion picture and broadcasting, and utilities. See Labor Code 512.1 C through G, Section 226.7. Rest periods. Wage Order Number 7, Section 12 provide for paid off-duty rest periods. 1, 10-minute breaks accrue every 4 hours for major fraction thereof. Brinker, 53 California 4 at 10:29. Now, on page 6, again, continuing the discussion on rest periods. Not meal periods now, rest periods. Wage Order provides for paid off-duty rest periods. 10-minute breaks accrue every 5 hours or major fraction thereof. 2 hours or more is a major fraction. Work less than 3.5 hours, no rest period is required. Rest period is considered hours worked and must be paid. From the case titled Augustus versus ABM Security Services, Inc. in 2016, the worker owed 1 hour of pay for every day not afforded proper rest periods in accordance with Labor Code Section 226.7. H must be relieved of all duties and control from Augustus again. And I, worker owed 1 hour of pay for every day not afforded proper meal periods. Wage Order Number 4, Section 12, Labor Code 226.7c. Pay records. Employer must provide pay stubs detailing, among other things, all rates of pay, deductions, and hours worked. Labor Code Section 226, Wage Order Number 4, Section 7b. For 3 years, employer must keep worker's name, home address, gender, occupation, regular rate of pay, basis for salary or wage, hours worked, wage paid. Wage Order Number 4, 7a. And then you have timing of payment. Subpart 7. Labor Code Section 204A provides all wages earned by a person in any employment are due and payable twice during each calendar month. And number 1, under this section, labor performed 1st through 15th of the month must be paid by 26th of the month. Labor performed 16th through the end of the month must be paid by the 10th of the next month. Wages for Section 204 purposes include all amounts for labor performed by employees in every description, whether the amount is fixed or ascertained by the standard of time, task, piece, commission basis, or other method of calculation from Peabody versus Time Warner Cable Inc. in 2014. Now on to page 8, which is a new section titled Exemptions to Wage and Hour Requirements. And there is an outside salesperson exempt from all wage order requirements. I'm skipping the details. Just remember outside salespeople. White collar exemptions include executives, administrators, and professionals who meet salary and duty tests are exempt, as well as executive exemption. An executive is one who manages a distinct unit. According to 29 CFR 541.102 and 541.104. Also, the exception comes from wage order number 4, section 181, further defining executive that they manage a distinct unit, that they direct the work of 2 or more full-time employees, and has hire and fire authority. And lastly, 4, customarily and regularly exercises discretion of independent judgment, which exercise of discretion and independent judgment under the executive exemption implies that the person has the authority or power to make an independent choice free from immediate direction or supervision, and with respect to matters of significance from the UPS wage and hour cases. In California, Appeal Court, the Fourth Circuit, 2010. Although the Fourth Circuit, okay, this is appeal in California, not federal. Must also spend at least 50% of time on managerial duties, which include interviewing, selecting, training employees, setting pay rates and work hours. We're still defining executive here, right? And what executives do, directing. And what do they do again? The specific terminology used for what executives do. Exercise of discretion and independent judgment. So interviewing, selecting, training, setting pay rates and work hours, directing work of subordinates, keeping production records on subordinates, evaluating job performance, resolving employee complaints and grievances, employee discipline, planning work, disciplining work, and determining work methods, controlling flow and distribution of merchandise, materials, or supplies, and providing for safety and employees and property. Work of the same kind performed by the supervisor's non-exempt employees generally is non-exempt even when that work is performed by the supervisor. If such work takes up a large part of the supervisor's time, the supervisor likely is non-exempt employee. Positions commonly misclassified as executive as working or straw managers who perform regularly same work as subordinates, and assistant managers rarely exempt because not in charge of unit. Section 29 CFR, section 541, 105, 541, 116, administrative compensation, wage order number 4, section 1A2, an administrative employee is one who performs non-menial work directly related to management policies or general business operations, or as a school administrator. It's the same section of the Code of Federal Regulations. Customarily and regularly, this is the second prong of the definition, customarily and regularly exercises discretion and independent judgment, and who functions as an executive or administrative assistant for staff employee or carries out special assignments, coming from the same section of the Code of Federal Regulations. And also, 4th, must also spend at least 50% of time on administrative duties, which include advising management, business planning and research, negotiating and or representing the company, purchasing and promoting sales generally, but individual sales work not ordinarily exempt. Now, 5th, administrative work must be both qualitatively administrative and quantitatively. It must be of substantial importance to the management or operations of the business. From Harris versus Superior Court. A true administrative employee engages in running the business itself or determining its overall course or policies. From Bothell versus Phase Metrics Inc., 2002 in the Ninth Circuit. So that's a federal case. Internal quotes omitted. Examples of employees misclassified as administrative: claim adjusters from Bell versus Farmers Insurance Exchange in the Fourth Circuit of Appeals in California. 2, television sports anchor reporter. These are employees misclassified as administrative. Just examples. Television sports anchor reporter comes from Nordquist versus McGraw-Hill Broadcasting Company in California's appeal circuit, Fourth Circuit of Appeals, and loan underwriters, Davis versus J.P. Morgan Chase and Company. Loan underwriters are not administrative as they were not at the heart of the company's business operations. They had no involvement in determining the future strategy and direction of the business, nor did they perform any other functions that in any way related to the business's overall efficiency or mode of operation. D, probation officer, Pratt versus County of Los Angeles in the Ninth Circuit. Loan officers, escrow closers, insider salesperson. So for loan officers, it's Casas versus Conseco Financial Corporation. This is a Minnesota case in 2002, loan originators for finance company. Escrow closers, Reich versus Chicago Title Insurance, a Kansas case, 1994. Escrow closers carry out defendant's day-to-day closing operations and thus are non-exempt. And lastly, insider salesperson, Martin versus Cooper Electric Supply Co. Inside salespersons for an electrical products wholesaler who spent majority of their time making telephone sales or in work closely related to selling where not administrative employees. Donovan versus Rockwell Tire and Fuel Inc. Salesman at a tire retailer was not administrative. Subsection O, professional exemption, wage order number 4, section 1A3. Professional includes license holders in law, medicine, dentistry, optometry, architecture, engineering, teaching, and accounting. These are professional exemptions. Law, medicine, dentistry, optometry, architecture, engineering, teaching, and accounting. Page 11. There's only 3 more pages here. So, in page 11, we're still talking about professional exemptions, talking about does not include many nurses. Professional also includes those in learned or artistic profession, defined as someone engaged in work that requires advanced specialized knowledge or instruction and study. Same section of Code of Federal Regulations is where that comes from. Is original, creative, in an artistic field, same section. And lastly is intellectually or varied in character. Exemption may apply to professionals who have not yet obtained a license or who perform low-level professional duties. See Zelasco versus Barrett and Brayton versus Purcell, LLP, 198. I'm sorry, I'm not reading the case citation. It's California, 2011. Law clerk with law degree but waiting for a bar exam results, engaged in professional activities, making him exempt professional. Heenig versus Quinn, Emmanuel, Urquhart, and Sullivan, LLP. That's the case with the junior attorney, or the law clerk, I should say. Contract attorney's work on document review project required him to exercise the type of judgment necessary to be engaged in the practice of law and thus exempt as professional. See also Campbell versus PricewaterhouseCoopers, LLP, Ninth Circuit tribal issue of fact whether unlicensed accountants working for an accounting firm were exempt on the professional and administrative exemption. And paralegals and legal assistants are typically not professionals because an advanced degree is not required prerequisite for most paralegal or legal assistant jobs. And you can see the same chapter of the Code of Federal Regulations for that, as well as whadmin.op.FLSA. Well, that's the Fair Labor Standards Act, maybe. 2005, WL 330608, January 7th, 2005. Computer professional exemption is listed here and exempts highly paid skilled workers, skilled computer system analysts, programmers, and software developers who are primarily engaged in intellectual or creative work that requires existence of discretion and independent judgment, highly skilled and proficient in theoretical and practical application of highly specialized information to computer systems analysis, programming, and software engineering, and third earns a minimum hourly rate of $45.41, annual salary of $94,603.25 in 2019, adjusted yearly on CPI, see Labor Code Section 515.5. Other exceptions, commission salespeople applies if more than 50% of total compensation from commission sales and makes more than 1.5 times the minimum wage, wage order number 4, Section 3C. And the two-part test under that type of a salesperson referred to as the commission salespeople. And two-pronged test is first, the employees must be involved principally in selling a product or service, not making the product or rendering the service. Second, the amount of their compensation must be a percent of the price of the product or service. And this comes from the Ramirez versus Yosemite Water Co. Inc. in 1999 in California. Motor carrier. California exempts truck drivers whose hours of service are regulated by the United States Department of Transportation under federal regulations. Chapter 49 of the Code of Federal Regulations, Section 395.1 through 395.13. These regulations apply to trucks with gross vehicle rating in excess of 10,000 pounds that travel in interstate commerce. Wage order number 4, Section 3I. Other miscellaneous exceptions include ambulance drivers of attendants on 24-hour duty, broadcasting industry announcers, news editors, chief engineers in small towns, camp and student employees and counselors, irrigators in agricultural occupations, motion picture industry, extra players, motion picture projectionists, and ski industry employees. Now, subsection 9, wrongful deductions and indemnifications for business expenses, DP, which I want to say is probably due process. Labor Code Section 2802, an employee shall indemnify his employee for all that the employee necessarily expends or loses in direct consequences of the discharge of his duties as such, or in his obedience to the instructions of the employer, even though unlawful, unless the employee at the time of obeying such directions believe them to be unlawful. 1. Examples of business expenses employer must pay for is vehicle use, gas insurance, repair, maintenance, depreciation, other travel tools, business promotion items, computers, cell phones, tablets, insurance. Labor Code Section 221 through 24 delimit what employers can withhold from accrued wages. Employer cannot collect or receive wages already paid but paid the employee. Employer cannot take deductions from wages for cash shortages, breakage, loss of equipment, and other business losses that may result from employer's simple negligence. And see also, okay, so there's a lot of cases here expanding upon this employer cannot collect or receive wages already paid the employee. The employer cannot take deduction from wages for cash shortages, breakages, losses of equipment, or other business losses that may result from the employer's simple negligence. And the citations are Kerr's Catering versus DIR in 1962, Barnhill versus Saunders in 1981, Quillian versus Lion Oil in 1979. See also Procassayoradiege versus Ralph's Grocery Company in 2004. Calculation of, in parentheses, that is the calculation of profit-based bonus lawful even though it incorporated charge for workers' compensation costs and cash and merchandise shortages. Now, number 2, under employer cannot collect or receive wages already paid the employee is chargebacks on commissions for customer returns may be illegal if employer has already enjoyed benefit of sale or cannot attribute the return to a specific employee. C. Shiborski versus Packbell DIR. In 2012, Hudgens versus Neiman Marcus Group Inc. in 1995. Now we're on the last page. No, we're not. We're on page 13. We've entered into paid time off, which will be followed by independent contractor. So only 2 more sections. Part 10, employer doesn't have to provide paid vacation, but if it does, the vacation pay is treated as a wage. Labor Code section 227.3, vacation plans may not have a use it or lose it provision, but employer can cap how much employee can accumulate. Vacation pay must accrue proportion to the amount of work employee puts in. For example, vacation accrues each pay period. Suastes versus Plastic Dress Up Co. in 1982. Employer cannot set an arbitrary date or accelerated earning period which would allow for a disproportionate rate of earnings. For example, cannot grant vacation in lump sum. 2, can't require employee to work entire year for her vacation pay to vest. Subsection V, pay time off is treated like vacation if there are no conditions placed on when it can be used. CDLSE Enforcement Policies and Interpretations Manual, section 15.1.12. Subsection W. Cause of action doesn't accrue until actual vacation time is forfeited, which usually means not paid at time of commission. See Church vs. Jamison in 2006. And under that, this quote is given, thus can recover vacation accrued but not used throughout employee's California tenure. Now, subpart X, most employers have to provide at least 3 sick days per year, or 1 hour for every 3 hours worked. Labor Code 245. 1, eligibility begins after 90 days on the job, and 2, must be tracked on pay stubs, and 3, can carry over unused sick leave year to year, but employer can cap amount to 48 hours. 4, no entitlement to cash for unused sick leave at time of termination, and 5, may not apply where there is CBA. Independent contractor classification. If a worker has been misclassified as an independent contractor, then likely not receiving overtime, meal periods, and is likely paying employers business expenses. See, for example, Alexander versus FedEx Ground Package Systems, Inc., 9th Circuit, 2014, and Narayan versus EGL, Inc. in the 9th Circuit again in 2010. Last subpart B, which is still under independent contractors. A worker is an employee and that's protected by California's overtime, meal, rest, minimum wage, and record-keeping requirements unless the hiring company can show all the following. A, that the worker is free from the control and direction of the hirer in connection with the performance of the work, both under the contract for the performance of such work and in fact, and B, that the worker performs the work that is outside the usual course of the hiring entity's business, and C, that the worker is customarily engaged in an independently established trade, occupation, or business in the same nature as the work performed for the hiring company. Labor Code section 2775 and Dynamex Operations West, Inc. versus Superior Court in 2018. So that's going to be the entire T of the outline. Thank you so much for preparing it for this subject matter area of law. And that big thanks goes out to Mr. Kaufmann.